And now, to address the legal concerns of the community, Praise AM 1310, 95.1 FM, presents Legally Speaking. Here are today's hosts.
Good morning today, everyone. This is Nathaniel Lee. I'll be joined today by my superstar panel, Attorney Milton out of LA and Attorney Vanita Banks out of Chicago. Also, I'd like to welcome today to our live audience from Atlanta, Georgia. Hello for Atlanta. Thank you for joining us today. Chicago, also Pasadena and Indianapolis. Thank you all for joining us today. We are a live call-in show. During the course of broadcast, we had you on a delayed broadcast. Today will be live, so our call-in number is 833-653-3529. I discovered that after the show, we would have these call-ins, and so now you'll be able to call in during the actual show today, starting going forward. So thank you for participating. In any event, today, there was a lot of news that hit the airwaves this week, but the biggest case dealt with the 14th Amendment case that went from Colorado to U.S. Supreme Court. The U.S. Supreme Court is spending an extraordinary amount of time dealing with Trump cases and issues. But this case out of Colorado was fascinating. It was brought by Norma Anderson, who watched the intruders storm the U.S. Capitol 3 years ago on television from a home in Colorado. And she was thinking, they're trying to overthrow the federal government. Anderson is 91 years old and a lifelong Republican. She was the first woman to lead the Colorado House of Representatives and later a state senate. She thought that taking part in filing a lawsuit is protecting democracy. She was born in the Great Depression. She lived through World War I. She remembered Hitler, and she remembered Eisenhower. And so with all that, she led the charge to try to keep Trump off the ballot. Now, she was saying those who drafted Section 3 of the 14th Amendment back in the 1860s were very clear. They understood this provision not to just cover former Confederates, but it would stand as a shield to protect our Constitution for all things going forward. So this was what this case was all about. They were using the 14th Amendment to disqualify candidates from running for office. Now, this has been used successfully. Since 1860s, there's been 8 cases, but most recently 2 years ago, in the case of a county commissioner from Mexico who wanted the trespassers at the U.S. Capitol on January 6th of 2021, he was denied the ability to run for office because he was involved in an insurrection. So there we have it. And I heard a portion of the Supreme Court argument this week, and I didn't participate in the whole thing, just a little bit, a snippet. But the one thing I heard, one of the justices said, does the state of Colorado, I think, have the right to make a decision for the rest of the 49 states? And I was thinking to myself, when the justice said that, that's exactly what they did with the abortion case, counselors. In the abortion case, they decided that a state can make rights that pertain to women and their rights to things of preservation of their own decision on their healthcare needs. And I was thinking about that. So in the abortion case, they were saying states have rights, but I think in this decision, the Supreme Court's going to say states don't have right to kick Trump off the ballot. That's my thought. There you have it. Attorney Banks, I know you've been watching this very carefully too. What do you think?
I listened to, and good morning, listening audience. I listened to a large portion of the arguments this week, and it seemed through the 9 justice questions, or virtually all of them, that this court is desperately trying to avoid a determination that the former president engaged in insurrection. I believe that their thought process is that they don't want to get involved in the political aspects of this election, and that they are straining through their questions to rule very narrowly in this case. There was a lot of discussion around the distinction between what does the word office mean in the 14th Amendment, Section 3, versus who is an officer, and whether or not the president is an officer under the 14th Amendment. There were a lot of questions, as you say, Attorney Lee, regarding whether the states should be making this type of determination, and that if a state such as Colorado could rule that a candidate is ineligible to be placed on the ballot, then other states could make the same ruling. And they were very, very concerned about that, the justices, through their questions. But Section 3 clearly states that anyone who engages in a insurrection cannot hold office. I also pulled the Federalist Papers, number 69, which compares and contrasts the U.S. presidency with a monarchy, and the office of the president, and the president is specifically referenced as a officer of the United States.
Amazing. Attorney Grimes, what was shocking, the Trump lawyers argued before the Supreme Court. Their defense was former President Trump is not an officer. He's not an officer of the United States as the term is used in the Constitution. I mean, that was I was thinking of all the defense. You're saying that a guy who get a paycheck from the federal government, who took an oath, is not an officer.
Nate, may I just add my 2 cents, please?
Yes, sir.
I was fortunate enough to represent a federal judge, a district judge, some years ago, who asked me to represent him in another federal judge taking a case away from him because he felt as though the judge I represented was biased towards a particular police department because of a previous ruling of his that said the officers from this particular city lie. They lie repeatedly. And so another judge took the case. And so I had to go to the presiding judge and say, what's happening here? How can a fellow judge take a case away from another fellow judge? He said, Milton, I don't tell them what to do. I don't run this court. I'm just a figurehead. But each judge decides their own autonomy here. They decide what to do in their court, believe it or not. And I found that to be fascinating. And I talked to my judge and learned, he said, you know, Milton, we're just like everybody else. When we sit on a case, popular opinion influences us a lot. I said, no, you're a federal judge. You got a lifetime appointment. You don't have to worry about getting elected. He said, we're just like all the other judges, state court judges, district court judges, appellate court judges, because we all see a higher position. And we want to appease the public sentiment and the public's wishes. And we interpret the law somewhat accordingly. And so the strict interpretation of the law that we sit here and argue about, I'm sure sometimes that applies. But when you're talking about an issue as large as this, when you're talking about the President of the United States, I now understand somewhat how this thing is probably going to be unsettled, and Donald Trump is going to run regardless, and he might win. He might win. I read recently in a book called The Lost Indictment of Robert E. Lee. They got a grand jury indictment against Robert E. Lee out of, I think it was Norfolk, Virginia. And then they debated, where are we going to try him? If we try him in Virginia, he's not going to be found guilty because no 12 jurors are going to find Robert E. Lee guilty in Northern Virginia, in any part of Virginia. So where can we try him? And there was debate going back and forth. And Grant, the general of the Union Army, said, if you try him, I will resign from the Army. I will surrender my commission. I will not participate in this government if you try Robert E. Lee, even though he was instrumental in fighting Robert E. Lee throughout the Confederacy. But they went to West Point together and they were friends. And he said, no, we cannot make this man a criminal. And do you know that indictment lingered and they couldn't decide, and finally the public outrage and everything calmed down, and they call it the lost indictment. They never tried Robert E. Lee. They tried some of the other Confederate leaders, but they felt as though Robert E. Lee was too popular among population and it would start another civil war. Follow me? And so I don't know if we got a precedent set that's going to control the outcome of this, or the precedent is that we got to keep this thing going, because do we make a decision that will cause a civil disorder to occur in this populace, in this government we have here? Or what do we do that we feel is, I don't know if it's the best thing or the most political thing or what, but we may never get an answer from the court on this thing that will stick for Trump.
Fascinating. Thank you. Okay, we'll go to caller. Imhotep, you have a comment for us today, sir, about this issue.
Yes, pardon me. Yes, I do. Thank you. Good morning to all y'all. Apparently, thanks and Brian. You're completely. I kind of figured it wasn't going to be answered in the first place. Now that you give the history of Robert E. Lee, and I read a lot of the text from Robert E. Lee. Matter of fact, Robert E. Lee, when we had these arguments in South Carolina, Nikki Haley, and Virginia, I think the Lee statue and stuff like that, Robert Lee specifically said not to erect any monuments or statues in his name because he felt that he wasn't deserving of it. So we can see how that went. I just want to posit one thing with this whole situation. This is Black History Month, and I read a piece the other day from NPR called "The 5 Speeches of Martin Luther King That You Should Read," and "I Have a Dream" is not one of them. And I go to the one of the three evils when he spoke of militarism, racism, and poverty being evil. And King said, white America has always had a schizophrenic behavior with the issue of race in this country. On one hand, they champion all the accolades and precedents of democracy when it comes to them. And then on the other hand, they act in the total antithesis of democracy when it comes to everybody else, especially us. And that's what we see here. He's getting the thorough, all the things needed in democracy for Donald Trump is for himself. But yeah, we can know what I mentioned last week about cases. You talk about judges. We know judges are biased. That's what we got to prove. We got the evidence of them being biased for us. But he's allowed everything that has to be fair in this democracy for this Caucasian gentleman. Because I bet you if that was the former President Barack Hussein Obama, we would not have the Supreme Court wouldn't have a problem ruling against him. I would safe to say they would rule against him if it was him with the January 6th situation, 91 charges, being found liable, being found to have committed rape. That's what the judge kept saying. I found you committed rape and all things like that. So Brother Grimes, Attorney Grimes, I love you. And I know what you said with the federal judges and what they say, but I caution with pause over the 50 years of my mother being an attorney and things she's told me she's seen from judges in the courtroom. And definitely when it comes to us, they have a schizophrenic, they have a dissociative nature when it comes to themselves. We see it with DUI arguments. We see it with arguing about pilots and Harvard, young woman at Harvard, and all kind of things like that. So he's being allowed to get every fact of democracy that can help him, whereas we've never had that here.
I don't disagree with you, Pierre.
No, this is Brother Imhotep. This is Brother Imhotep, not Pierre. This is Brother Imhotep.
Okay,
Brother Imhotep.
I'm sorry.
Well, one of the things that I thought is critical is that I looked at the poll numbers. It's just shocking. We have a person with 91 indictment, had been adjudicated to be a fraudulent business practice. Anybody else would have been in prison for that. Had a client, did one financial form and got 42 months, and looked like all his business dealings had to do with fraudulent. Admitted sexual assault person, verdicts against him for sexual assault, rape, and defamation of $88.3 million. And it's just incredible to me that somehow nothing sticks to a person that appeared to be fundamentally flawed. That's not a person you will have run for your local city council.
But he has close to 50% of this population supporting him. And that's his get out of free card. He's strong.
I was really amazed that the justices, again, through their questions, seemed very timid about using Section 3 of the 14th Amendment. And it's likely from their questions that they will rule that he is eligible to be placed on the ballot. And I would call that, as you stated before, Attorney Lee, regarding the decision regarding abortion rights, that's a matter for the states. But I would argue that this is situational federalism, right? Concern about states politicizing the issue by, keeping candidates from each party off the ballot. But these judges essentially potentially erase Section 3 from the entire 14th Amendment, because that's really the only way to hold people accountable that attempt to overthrow the government. And if it's stated that Section 3 doesn't apply here, I'm really concerned about, will we have rule of law if this section is not applicable in this circumstance? Because if not this circumstance, then I don't know what circumstance in which Section 3 would be deemed to be applicable. Again, on the issue of whether there was an insurrection, which the justices just didn't want to go there at all based on their questions.
They saw another wrong back in the 17th century, that the discussion and what to do about it was put off for 20 some years. And that is when they joined this union, they had to make an agreement. And it took a long time for me to understand that. that they were not going to discuss slavery or the transportation of slaves over here because it would split this union apart, and we would lose the strength of a United States, and England would take over again. So Congress made a decision. We will not speak of slavery in these chambers until 1806, I think it was, because of their fear of splitting the Union. And that was a decision that was made, even though the Quakers would try to stand up in Congress and say something about it's wrong. No, we made an agreement. We made a pact with South Carolina and them southern states. We would not discuss this issue until this union gets more bound together. And so that was a political decision dealing with a real serious political and social situation. And all I'm saying is that maybe this is where we need artificial intelligence running the government. You follow the law, and you follow the law, rather than you follow the law with the influence of the people, not just the law. So I don't want to confuse anybody or myself even, but I see it as a decision that maybe they think is too risky to make.
As we're leading up to this very contentious election, Attorney Grimes,
You were saying something else?
no, I was saying I agree with you as we lead up to this very, very contentious election. There are also arguments that there's no definition of insurrection in Section 3, and that this section really is not, quote, self-executing, and that congressional action is required. And of course, one of the arguments was that Congress must establish procedures to actually implement Section 3. But of course, that's not going to happen given this very divided Congress. So I agree, it's the kicking down the road. I agree with your point that these justices will likely not address the core issue and will rule on very, very narrow grounds, resulting in Trump being placed on the ballot. There are a lot of people that are arguing that as well, that he hasn't been charged with insurrection, right? There are conspiracy charges. There are 4 charges that Jack Smith has brought. None of them are charges of conspiracy, although there is a federal law against insurrection. Trump has not been charged with insurrection, but I believe that the Colorado Supreme Court got it right. They did hold that he engaged in an insurrection, and therefore he is ineligible to be placed on the ballot. And as Attorney Lee stated, there have been other cases, not at the federal level, but at the state level, I believe, Attorney Lee, that have ruled that candidates who have engaged in insurrection are ineligible to hold office. There is, of course, a safety valve that Congress can remove. The last sentence of Section 3 states that Congress may, by a vote of 2/3 of each house, remove the disability or the ineligibility to hold office. See, we have a caller.
Vanita,
Yes.
sorry. I haven't finished. I put it down. It's full of so many facts and facts. Rachel Maddox has written a book, I think it came out this year, about our law, and that our laws are intentionally written to be flexible, and so that we can get Jim Crow laws that apply and are enforceable, that we know are evil and wrong. We can get housing laws. We can get all kinds of laws written that we have to admit and unwrite later. But the purpose of the founding your fathers was to intentionally write the laws so that they would be flexible enough for these various interpretations and not to be rigidly interpreted. And that was done on purpose. For whatever that purpose was, I don't remember what she came to, but it was to afford them the opportunity to interpret them as they go along to be convenient for the moment. And maybe that's what we're facing here. They're not as rigidly written as we initially thought when we were in those walls of those law schools thinking we were smart. They are a little more flexible.
Okay. Okay, let's take one caller. Producer, let's go to the phone line. We'll take the caller. Caller, you have a question, or I mean a comment for us, a question. Go ahead. Producer Flintstone. Okay, did we lose that caller? Okay, we'll go to the next one. Okay, we'll go to Cox. You have a question or comment for us, sir, before we go to the next topic. Hello?
Hello?
Okay. You have a question or comment for us today?
Are you talking to me?
Yes, sir.
Yeah, this is Pierre. Hello?
Hey.
Hello?
Yeah.
Hello, Pierre.
Yeah.
We can hear you.
Good morning, Pierre.
Okay.
What's your question today, Pierre?
Thing.
Go ahead.
Here's my question. I was listening to Rick Hasen of
I can't hear you, sir. What's your question?
Can you hear me now?
Yes, go ahead.
Rick Hasen of the University of UCLA Law School out there says the problem is Trump hasn't been convicted of anything. Nobody's convicted him of anything. He hasn't been convicted of insurrection. So how can a state or anybody take him off the ballot, you know? And that's the problem. He has to be convicted of something, or by the Senate, or
does it require conviction, Vanita?
I thought the language said engaged in insurrection, and the court determined that he did.
Well, who made that determination?
The Colorado Supreme Court. They did a trial. They had an evidentiary hearing, and so, like in the Trump fraud case, for example, the court determined that the Trump business committed fraud, right? Or in the Trump rape case, a jury determined that Trump committed sexual assault on Jean Carroll. So net result is that that's a finding of fact. In our legal system, once you have those type of adjudication, what occurs is that the legal theory then called collateral estoppel or res judicata. So once an issue is decided, then it binding on a litigant, and that's the problem. So this issue had an evidentiary when the Republican Norma Anderson bought the lawsuit. They actually had a trial, and evidence is presented at a trial. So in theory, there's been an evidentiary finding of this insurrection in a court, which is a collateral estoppel type issue. And that's the fallacy with that professor's argument. You know, you can make an argument on either side of this, but the problem is that do you believe what people are saying, or do you believe your lying eyes? You know, we saw on January 6th on TV we saw people end up calling the death of a police officer. We saw people get shot. We saw the Capitol overrun. We saw people saying, hang Mike Pence. Now, to make things really bizarre, we have people who want to be a vice president candidate with Trump on TV this week saying that they would not have done what Mike Pence did. So in other words, they're saying that I would have committed a crime to disenfranchise 81 million voters in America. And that's where we are now. And so the issue is that do we vote to protect democracy, or we trying to get some other type of government? It's going to be really simple this year.
Well, did he? Well, you know, I think he let it. I think it was an insurrection, but what's an insurrection? Was that a riot or was it an insurrection? I mean, was it a? I mean, come on, Milton, you're the defense attorney here.
Tomato.
Well, if it had been black folks out there, what did you think it would be called?
If it had been Black Lives Matter,
they would have shot every last. Black folk wouldn't have made it. On the steps of. You saw the way they was ready for Black Lives Matter. But I'm just saying, you know, it just like the law professor said. I mean, okay, you say it's an insurrection. I believe it was, but. I mean, it wasn't was it organized?
Yes, it was.
It absolutely was organized.
In some place, I think it was organized to an extent, but how do you prove he did it? I mean, you know, it was a bad day.
Be honest with yourself.
It never should have happened. But you know, I understand the law professor's point. At some point, you mean. Somebody's got to be convicted of something by somebody.
Well, I don't know if I agree with that particular law professor. I've disagreed with the law professor before, Pierre, and I'm not afraid to step up on this one. I don't believe it requires a 12-member jury to convict him of anything.
Well, again,
in his case, it requires the Congress, doesn't it?
Well, that's what he's alleging. The justices didn't spend very much time with this. I believe that Justice Ketanji Brown Jackson, in her questioning of Trump's attorney, stated that they accepted that their actions were a insurrection in their opening brief, but in the reply brief, they argued that the actions were not an organized attempt to overthrow the government and not an insurrection. And so it seemed to me that Justice Jackson was suggesting that in the opening brief, they conceded insurrection, but then they flip-flopped in the reply brief. I'd like to go back and
that's because the response was too strong for them, so they had to change their direction a little bit. That happens all the time.
Exactly. Great point, Attorney Grimes.
Wow.
Hey, one last question for Nate. With this border deal, let me ask you this. Why couldn't the president and the Democrats in Congress just say, hey, you know what? We're going to let you guys write the bill for the border. Just write it. And you send it up here and we'll sign it. And the president could have put the Republicans in all kinds of a trick bag. He could have told them, I'll sign whatever you send up here.
Okay.
Why stop drinking that coffee you drinking in the morning, boy?
Okay. Well, thank you very much, Pierre. Let me, real quickly, that's a little bit off topic. Let me address this real quickly, and then we're going to go to the next caller. First of all, a border bill is important because in order to have enforcement, you have to have dollars to pay for staff. So the border bill has a bunch of different components. You have one for funding of agents. So the biggest part of it is that you have to hire more people to defend the entry into the country. And so the second component is that America has always had immigration. Only Native Americans are here. Everybody else came either as slavery or they were immigrants. So we've always had this problem. And so you have to have a legal system in place to handle the legal issues that come with each individual. So the border problem got a multitude of legal issues. Each of the issues requires money. In order to get money from the federal government, you have to have the House and Senate agree to appropriate money. And so the border issue had to do with the fact that Langford, one of the most conservative members of the Senate, was on, along with Mitch McConnell. They all had input. They put in all these provisions that they all agreed to. And one person say, it's bad for my re-election, Donald Trump. And so they all flip-flop. Now, everybody forget about something that very similar happened during Trump presidency. During Trump presidency, the country got shut down. He thought that people could cure COVID with bleach, and that didn't work, of course. And then, but for the intervention of the Congress, the United States would have went into a Great Depression. And so even during the election year, the Democrats agreed to give people a massive sum of money. And when they sent out the check, Donald Trump insisted the checks were delayed because he insisted that his name be on the checks. So people thought when they got these checks that Congress approved this money, then the money came from Donald Trump. So the point I'm making is that the Democrats, during a crisis, agreed to give Trump that ability to do that, but Republicans saying hell no. So the point is that each of these legislators took an oath to serve the country, the United States of America. And unfortunately, they failed their oath, in my opinion. Now, next caller, Mr. Cox.
Can I ask you a question, Nathaniel?
Yes, sir.
Is it confirmed that Trump really thought Clorox or bleach would cure COVID if you ingest it?
Well, that's what he stated.
And that's what my eyes saw on TV.
And that's what your ears heard?
My eyes saw on TV, he said that.
Okay.
And you know what? The doctor on the stage didn't say, man, have you lost your freaking mind?
So how can we support a man who thinks like that?
No, in other words, the people that sit on the stage say, you're a lunatic. If you ingest bleach in your system, you're going to kill yourself, you dummy. I'm thinking, are these people out of their freaking mind? They didn't even try to correct them. You know why? They were afraid to.
There you go. There you go.
Next call real quickly.
Hey, Attorney Lee, listen, Flintstone here, I got to tell you, you've been talking about all this national stuff with Trump. Let's face facts. He'll be there in November going against Biden, and we'll try to figure out what's going to go on. But at the end of the day, what I'm concerned about, Milton, you got a governor in your state, and Attorney Vanita, you got a governor in your state. Have they sent anybody to the border? Because Attorney Lee, I don't know if you addressed this. I'm late getting to the program, but Holcomb, our governor, just sent people down there to help that crazy Texas governor put up barbed wire to keep people from coming into the country. This is really strange, man. He's on his way out for Indiana, but our governor is sending people down there, sent the National Guard down to help support it against what the federal government's trying to do. So, Milton, Vanita, I don't know if your governors are doing the same thing. I doubt it. But Indiana,
I saw that standoff in the paper a couple of weeks ago.
Welcome to, as Malcolm always said about Indiana, it's up south, not down south. It's up south.
Right.
Like you guys addressed it, I'll turn it off and listen to you.
Yeah, I tease Nate about that off and on.
Our governor has not sent representation down to the border that I'm aware of, at least recently, but our mayor, Brandon Johnson, has done so.
Well, my position is real clear. There was a bill that the Republican put together. The Democrats agreed to it, and Donald Trump sabotaged it. So the border issue failed solely because of one person, Donald Trump. He manipulated the House and the Senate to vote against a bill to solve a crisis. See, you can't solve a crisis in Congress without appropriating money. And so regardless of what the president say or do, ultimately you have to have money to house people, you have to have money to, you have Border Patrol, ICE agent, the whole thing requires money. And without the appropriation of funds, you're not going to have any resolution of the issue.
That's
well, calls on this issue, we're going to move on to the next issue.
That's absolutely correct, Attorney Lee. I agree with you wholeheartedly.
Yes. Ethan Crumley, 15-year-old disturbed kids, committed a mass murder at Michigan Oxford High School a few years ago. A judge sentenced the 15-year-old to life in prison. This week, the jury found his mother liable for involuntary manslaughter. She is going to spend a substantial amount of time in prison for the murder of her 15-year-old son. So now a parent is being held accountable, for the murders committed at school by her 15-year-old son. That's the point of beginning on this issue. So now we've ushered into a new phase in our legal system. Parental liability for mass shooting of a teenage son. That's where we start. And it should serve as a wake-up call, Attorney Grimes and Banks, for a lot of these parents who are big Second Amendment advocates. Now we find out that at least one jury determined that the wrongs of the son become wrongs of the parents.
Well, I got a question. Is it based on a strict liability premise, or is it based on a knowledge premise that the parent is held liable? Are you liable because I bore this child and I'm responsible for everything this child does until he reaches majority? Or do they have to show some action or lack of action by the parent in addressing this child's condition? Now, I understand, and I'm not probably as well versed on it as you are, Vanita, but I understand this mother was saying the father was responsible for this boy's use of this weapon, and she was just responsible for the home activities and the raising of this child, but had no responsibility for his use or his use of this gun. That was his father's responsibility. Now, the father has not been tried. I don't know what his defense is going to be. But I wonder, is that a good, Nate, people reacted to this thing, and I wonder how much evidence they had to show that she had knowledge of this young man's potential to do what he did. That's my concern. I would hate for this to be based on strict liability. You follow me?
Yes. Well, in response, counsel, I've always sued parents of kids in collected settlements in civil cases since the beginning of my practice. You have secondary liability on a bunch of legal theory on the civil side. For example, when kids are murdering other kids, the theory is that you have a duty to secure your weapon, right? So back then, we used to have people have a gun permit or gun license or a permit to carry. And now we eliminate that. Our state went crazy and enacted a law and said we don't have to have a gun permit anymore. We don't have to do the background check. So now, but it still does not negate the civil liability of the parents. So
if the kid runs away from home at 16, and we do a massive manhunt, and we don't know why he ran off with some other kids, and he kills someone intentionally or unintentionally, I'm liable for that?
Well, it depends on the circumstances.
Well,
when
that's right.
the kids ran off, were you negligent in allowing him to have access to your loaded weapon?
Broke out the window, broke out of the
2,000
window
rounds
at
of
3 o'clock in
ammunition?
the morning. He broke out the window at 3 o'clock in the morning and ran off. And I was taking him to church every Sunday and providing him every health care a parent can give him. Am I liable for that?
The issue is the weapon that he used, did you supply the weapon, yes or no? The
He
issue,
said he found the gun at somebody's house they
well,
broke
that's
into. He
different
didn't
then.
leave him with
Okay,
no
then
gun
the
because
parent's
we don't
not
have
liable in
any.
that situation. If it's the source of the killing, do you provide the AK-15? Or
But then
if
that
you
answer my
provide the
question.
weapon, you have liability. If you don't provide the
That's-
weapon, I think that there's no ground for civil nor criminal liability, in my opinion.
Okay, thank you. Thank you. Thank you, sir.
Now, according to government report, 76% of school shooters got their firearm from the parents or close relatives. So the point of this is that we should have a lot more civil liability, and maybe it's a great thing, and here's why. We have to address this violence in America. Somebody was telling me last week, or this week rather, man, they had somebody got shot in Jamaica, so they have a travel alert for tourism. I said, are you out of your freaking mind? I said, the most dangerous country in the world is the United States. We got over 400 million
Right.
guns. We have more shootings in the United States than half the world combined. So we're the most dangerous country in the world now. Why? Because we have a proliferation of guns everywhere. Everybody got guns. And we think that somehow is protected by the Second Amendment. I think the Second Amendment, Milton, Vanita, should have more limits. I don't think the Second Amendment, the founders ever thought about AK-15, weapons of mass destruction, to allow people to kill unlimited amount of people. You know, we have to put some limits on this. We have to put the brakes on this.
I agree in this situation. She's charged with involuntary manslaughter, which is not strict liability. At the heart of the case is whether she should have foreseen and prevented the deadly crime. And evidence suggested that she and her husband bought the gun just days before the shooting, and that they should have known that their son was suffering from deteriorating mental health. He had complained of hallucinations. The parents didn't, get treatment for him. She stated that she didn't think that her son had mental problems, but when she was confronted with this very disturbing drawing, at the school, she declined to take her son home. And so I think that based on the facts in this case, the jury concluded that the outcome was foreseeable and unanimously convicted her in this case. And I think the husband's going to follow, suit. And of course, this is the first time, this is a huge precedent-setting landmark case because it's the first time that a parent in the United States has been convicted of manslaughter as a result of a mass shooting carried out by their child.
Well, I don't know the extent of the evidence towards either mother or father, but I surely would require some strong inference, if not actual knowledge. And one day is a pretty short period of time to come to a conclusion that he's going to take this gun and go kill fellow classmates. I would hate that this was a reactionary jury to the pressure of society. And I don't know if this is a precedent-setting case necessarily. I don't know the facts. So I'm gonna leave it like that, but I am a little concerned knowing what today's kids are exposed to on social media and peer influence. And I mean, I've seen kids at 12 and 11 emancipate themselves damn near, and the parent has no ability to control them. I'm just concerned about this being a precedent that if based somewhat on strict liability, but you say that the parents knew that this child had an inclination to do something like this, and maybe that would change my mind. I just don't know all the evidence.
Okay, let's go to the caller. Caller, you have a question or comment for us today?
Hello.
Hello, caller.
Yeah, this is Guy, folks. Hope everybody's doing okay in this historic month.
Yes. What
Hello,
city are you
Guy.
calling from, Guy?
Beg pardon?
What city are you calling from?
Indianapolis.
Okay, go ahead, sir. You have a question or comment?
Yeah. In terms of what you were speaking of earlier, I think that we have to know the facts, because we're in the age of in Scripture it says the age of wheat and tares, and we have to look closer in terms of everything that's happening, because as a recent decision that was handed down, they talked about whether or not Donald Trump and his escapades with classified documents and the escapades of President Biden and his classified documents, the Republicans are taking it that we're talking about oranges and oranges, but actually I think it's a case of apples and oranges, because in Donald Trump's case, he refused to hand over the classified documents after it was brought to his attention that they needed to be returned. And in Biden's case, he did turn over the documents, but the Republicans are trying to make it that basically it's the same situation, and it's not. But I think people need to worry about the difference and bring out the difference, because otherwise this is what the backers of Donald Trump have been doing all along. Also, I wanted to know, as professional legal attorneys and whatnot, have you been surprised by any of the developments regarding Donald Trump's legal cases at this point?
Well, what I'm surprised about is that the axiom of being a democracy is that no person is above the law. And so that is important for democracy. We don't elect kings. We don't elect dictators. We elect public servants that are given oath to uphold the Constitution. And so with 91 indictments, adjudicated rapists, I mean, it's a radical departure from norms. And what we've seen occur is abnormal criminal behavior is become normalized. We see it every day. We're flooded with this information, misinformation, and somehow it become normal. So you would not elect to your local school board, your local council, a person with this background. But yet, somehow, he is very popular according to polling. And it's something that unprecedented in American history. We've never seen anything quite like this before, starting back to the beginning of democracy. We've just never seen something this egregious. And the net result is we've normalized criminal behavior. That's my thought process on that issue, Milton.
It's it's not as simple as we want it to be. I mean, I just got sidetracked by the thought of the Super Bowl tomorrow and how much attention is being paid to the Super Bowl couple, Swift and Kelsey, the tight end and the singer, and how they got the Republican Party thinking that they can influence this election, and hopefully she will be able to bring out voters, and they will use their own mind to vote and do the right thing. But they say it's such a concern of the Republican Party that they have switched their allegiance to the San Francisco 49ers. And they always looked at the San Francisco 49ers as the representation of liberalism. You know, I went to school in San Francisco, law school at Hastings. And, you know, I love that city because it was so progressive and everything, but against people who think on the right side. But now the right side is saying San Francisco should win this game because they need that
are
show
not necessarily those of Praise AM 1310, 95.1 FM, Radio 1, or its management.
Hey, producer, cut off the radio. We'll keep going. Go ahead. Yeah, go ahead. Go ahead, Milton.
No, I was just saying it's crazy how the way this country is reacting and the way we're going. I don't know how long we can continue like this, Nathaniel.
Attorney Banks.
But
go ahead. Let me hear Attorney Banks first, then caller. Go ahead.
Well, I was going to just comment on Guy's comments that it's important, and it was done in the special counsel's report on the Biden classified documents, that he contrasted the actions of the former president with Biden's cooperation with the investigators. He agreed to searches of his home. He sat for a voluntary interview, 5 hours over 2 days. In contrast to the former president, willful retention of the documents. He refused to return them. After he was subpoenaed, he argued that he had the right to declassify the documents. He showed people who didn't have security clearance the documents. And so those differences were all addressed in the special counsel's report. And so I agree with you, Guy, that it's important to make these distinctions with respect to the classified document situation.
Hey, well, Guy, we got to end the show now, Guy, but you can call us back next week and we'll complete this dialogue because there's a couple more topics we didn't get to today. So I'd like to thank our audience for calling in today and our VIP guests and all our callers. Join us next week and we'll cover the legal issues of the day that are important to you and our community and our country. Thank you, everyone. Have a blessed day.
Thank you. Have a great week.